And a very good evening to you and welcome to today's edition of Politics 101. Welcome to all you viewers here on Facebook and those of you who are viewing us through YouTube. Welcome to you wherever you are in Guyana, in the wider Caribbean, in North America, in Europe, Africa, wherever you are. Welcome to today's edition of Politics 101, and it's always a pleasure to have you guys on. You keep us going. If there is no audience, there is no show. And so we are, of course, grateful to you for joining us. Well, tonight we are going to tackle the issue of the courts. As you know, the two UWI, University of the West Indies, professors have in fact questioned the impartiality, of the appeal court, Guyana's appeal court. And one of those professors was part of the CARICOM observation team that came to observe the recount during the elections impasse last year. Of course, the courts were very much part of the impasse, those 5 months, judicial review. Both sides were going to the courts and appealing decisions. Of course, we have a three-tier system in Guyana. We have the High Court, of course, and then we have the we have the Magistrates Court, and then the High Court, and then we have the Appeal Court, and then above that, the Apex Court, the Caribbean Court of Justice. In fact, the professors appear to be giving a vote of confidence to the High Court and the CCJ, and questioning the independence of the appeal court. Of course, it was an impasse, and there were two sides of the political divide taking their cases to the courts. The High Court came down most of the time on the side of the PPP. The Appeal Court came down mostly on the side of the coalition. And then we had the CCJ, which came down mostly on the side of the PPP. And here we have two professors who are questioning the independence of the court that came down on the side of the coalition, and giving a vote of confidence to the two tiers of the court that came down on the side of the PPP. Just to give a little background. So tonight we're going to be talking about that. And then last week, Attorney Roysdale Ford, who's the shadow legal minister in the parliament, that is, he's the member of parliament for the coalition that deals with legal matters, in a statement charged the PPP with weaponizing the courts of Guyana. So we want to tackle those two big issues tonight. We have with us Attorney Roysdale Ford, and we are going to be joined by Attorney Kemrat Ramjatan, who is leader of the AFC. and we're going to try to deal with these issues. My own view is that I find it quite strange that two regional professors, in a sense, are seeking to entangle themselves in the legal and political battles in Guyana. But more than that, I see it as an attack on the integrity of the legal system in Guyana, in particular the integrity of the Court of Appeal. Now, I'm a regional person. I comment on politics in Caribbean countries, in Antigua, Barbados, Trinidad. I'm usually asked to appear on panels to deal with local politics, and so therefore I am not saying that regional scholars should not comment on Guyana's politics or Guyana's legal system. We are part of the CARICOM region, and so therefore we are brothers and sisters. And so I am not taking a nationalist position here at all. I am not. I'm not, and I would urge my audience not to go there. For as much as supporters of the coalition are peeved at the CCJ, are peeved at the role that the CARICOM team played in Guyana last year, I've always said that we are regionalists. Guyana, the PNC, the WPA, the parties of the coalition are all regional parties and regional oriented parties, I mean. And we would not certainly like to encourage supporters to attack CARICOM, even as you are critical of the role they play. So I just want to urge us not to go down the road of ultra nationalism here, but to try to see the issues on their merit. I would also like to point out that some of us, even as we disagreed with our High Court in a lot of its rulings, we disagreed with the CCJ in a lot of its rulings. We were very careful to ask supporters to respect the court as an institution of our country, that you can disagree, but to respect your institutions. I personally, in my criticism of the courts, took the position that the courts in Guyana and in the wider Anglophone Caribbean tend to be very conservative in their rulings on matters that have to do with politics. They don't take a broad and expansive look or interpretation of the law from my standpoint. They tend to stick to the letter of the law, and so therefore we get the kind of rulings that we got last year. And so that was the standpoint. I do not subscribe to the view that the Chief Justice is PPP. That's not my business who she votes for. And when I look at our rulings, I don't start there. And I urge viewers not to start there. Because once we get down to getting personal about people who hold positions in our society, it's a very dangerous, slippery slope that we may have difficulty getting back. You see, today we are in opposition, and tomorrow we are in government. And so when you're in opposition, you have to be as responsible as when you are in government. as far as the institutions are concerned. We can't tear down the institutions when we are in opposition, and then when we get into government, we want the institutions to work. We in a sense, what I'm calling for is a new political culture. I understand our politics are very, very sharp and divisive, and our people are very politically astute. But I still believe that we have to have some kind of separation between our raw political views and our responsibility to our institutions. We have the responsibility of trying to keep our institutions together. Imagine if there were a Guyana or a Caribbean without courts. Imagine where we would be. Let's say the courts were to disappear tomorrow. Think about what kind of society we are going to have. And so therefore, yes, we can disagree with the rulings of the courts, but I urge that we have to have some kind of separation between that and trying to delegitimize the institutions. That's the PPP's way of doing things, you know. For its entire life, the PPP had no use of CARICOM. In fact, up to today, they don't have no use of CARICOM. You know, CARICOM came down on the side of the PPP in the political impasse, and that was useful to the PPP. But other than that, the PPP has absolutely no place for CARICOM and regional integration. From the PPP's attitude in 1956 to the Federation, when Dr. Jagan kept the Guyana out of the West Indies Federation, when all our sisters and brothers in the Caribbean joined that federation, Dr. Jagan and the PPP kept us out, kept Guyana out, on the grounds that if Guyana were to get in there, then the East Indians in Guyana would become a minority in a larger West Indian nation. And they kept us out of that historic intervention from 1958 to 1962. And then during the period of the PNC in power, the PPP would cuss CARICOM up and down and call them racist, that they were supporting the PPP for racist reasons. And in the 1990s, they flirted with a sub-regional organization comprising Guyana, Suriname, and Trinidad, all of which had Indian-dominated governments. So the PPP has never been regional integration. Regional integration has been championed by the PNC when they were in government and out of government. The fact that CARICOM Secretariat is in Guyana has to do with the PNC. The WPA came out of the regional movement. People like Clive Thomas and so on were part of the New World academic organization that started their analysis of our society with regional integration. Dependence and Transformation is a book written by Clive Thomas and another scholar whose name escapes me now, from Jamaica. And that was the Bible for regional integration. So the opposition parties have all been pro-regional. And, yes, I know people have been disappointed with the role that the CARICOM observation team played, with the role that people like Dr. Ralph Gonzalez and Mia Motley played in terms of helping regime change last year. But we should not give up. We should not give up our relationship to regional integration. And that's the point I want to make. So we are going to discuss that tonight. I wanted to give that background so as to frame our conversation. We have Kemrat Ramjatan and Roysdale Ford. Kemraj, a long time.
Hi, how are you doing? Yes, indeed, I was pretty busy, and
I noticed you were overseas.
that's correct. Yes. I had a good time. I had a good time. Didn't get to meet you over there, but I met quite a lot of relatives and friends and associates.
And how did your friends in Queens treat you?
Oh, they didn't turn up because most of them had indicated that my visa was taken away, and so I told them to come across and make the checks to see that indeed it was not taken away and that they're doing a lot of fake news. And then, of course, they started this other nastiness that I am there to deal with my Capital One bank account and my big house in Long Island.
Oh
Well, I
wow.
was staying by my sister, But that's the way of the PPP. They love to get you on fake, the false news, and that is predominant now. But I was there to straighten things out with them, but they didn't turn up.
They
So
didn't turn up. That is also part of their approach. Cameron
right.
Ramjatan here and Roysdale Ford. Hi, Roysdale.
Hi, good evening, Dr. Hanks. Thanks
How
for
are
having me on
you?
the show. Hi, Kemraj. I'm going good. Doing quite
You've
well.
been very much in the news lately.
Yes, I have been. I've been coming under all sorts of comments and attacks, but I believe that my statement is sound. And I guess on some future occasion, you will invite me to discuss that.
Yes, yes, yes. I'm certainly going to get you in shortly for us to discuss that. Tonight, we want to discuss these two issues. One that you frame as the weaponizing of the court by the PPP. And the second one has to do with the comments that were made by the two professors from the University of the West Indies. Let's start with your statement, Roysdale, on the PPP weaponizing the court. Please explain to us what you mean by that.
Well, Dr. Hanks, for the purposes of your viewers, I believe that the PPP has weaponized the court. The weaponization process relates to, first, the attempted effort by the PPP to pass the Fiscal Management and Accountability Act, which is to close off, in my opinion, the court's independence and access to resources and its budgetary planning. At the other end, there is a persistent use by the courts, use of the court, by the PPP to bring political activists and persons who do not support the views and policies of the PPP to the court through different trials, through different charges, and different interventions, which seem to be all permitted by the DPP. And this, from that context, within that larger frame, that they describe what is unfolding as the weaponizing of the courts by the PPP.
Let me press you there for the education of our audience. We do have some degree of separation of powers in Guyana. That is the three branches of government: the executive branch, which is what we usually call the government, the legislative branch, which is the National Assembly slash the Parliament, and then we have the judicial branch, the courts. And you said just now that the PPP, meaning the government, the executive branch, is using the courts. How are they able to do that when we have these three branches of government with a separate sphere of influence?
Well,
Explain that.
well, Dr. Hanks, they're able to do this in a number of ways. First, as I pointed out, in relation to the Fiscal Management and Accountability Act, where the court delivered a landmark decision rejecting the effort by the government to pass the legislation, the amendment of 2021, which sought to bring the courts and the other constitutional agencies directly under the control of subject ministers. So the courts and the other constitutional agencies would have had to go cap in hand, presenting their budget proposals to those subject ministers and to have their approval. So the court, in a very important decision, I believe there are aspects of the decision which I don't agree with, but substantively the large body of the decision struck down the Fiscal Management and Accountability Act in relation to the fact that they wanted to take control of the courts through that means. Because if they control the spending, they'll be able to control the policies, and they'll be able to affect the outcome and the product of the courts, which is really a fair justice system and the preservation and upholding of the rule of law. Now, the other way in which they would be weaponizing the court, Dr. Hines, would have been the fact that they would have been charging persons and instituting a number of proceedings, most of them, if not all of them, completely without merit and without any substance. How they would be able to do that, Dr. Hines? The police force falls under the direct control of the state, the government, as we want to put it in that way. So they're being able to use the basic function of the court, which is to hear charges and hear criminal proceedings and to hear judicial controversies. And they will be able to utilize that basic purpose and function as conceived by the Constitution, but for those purposes, which is basically then, Dr. Hines, a misuse of the very purpose that the courts exist. But the nature of the court system is that the courts would have to entertain those charges, have to deliberate on them. So that process itself is what I want to describe also as constituting the weaponizing of the courts.
The weaponizing and the use of the purse string in a way to control the courts and then weaponize them. Because although we have separation of powers, they're not complete separation of powers in that way. Kamran, let me bring you in here. Do you support or let me pose the question differently? Can you comment on Roysdale's position?
Yes, it is an important description. Some people might not like the use of the word weaponizing, but I believe that the PPP is doing exactly that, to make the courts bring fear into a number of people, and also to bring right-thinking people into thinking that they can control the courts by virtue of taking away budgetary allocations that normally would be scrutinized by the National Assembly and then putting it back into Ashni Singh's lap.
Yes.
That is an important the characteristic of the PPP's administration as distinct from the APNU AFC administration. And our administration was more akin to what the constitutional prescriptions are, that there must be financial autonomy in relation to the budgetary allocations of the court system and every other constitutional entity. And so when they then revoked the amendments that we had put in 2015, the very first thing we did when we got into government, they have now revoked and rescinded all of that. And that is what the courts have now ruled. Justice Harnanan, I have seen the decision. And yes, indeed, he indicated that that is a wrong thing that the PPP has done. But of course, you would have Mr. Anand Nandalal going in and saying that he has won the case. And you have, in my view, a servile press. And this is where, you know, a couple of years ago, I did an article, a major piece, as a matter of fact, that I had called out from a long paper I had done at University of London, Wither the Press. And it meant to say that our press can also be servile to certain masters, including the political directorate. And so that they are not going to put down the arguments, as I'm seeing here inside of this case with Justice Harnanan, that indeed Justice Harnanan ruled that this thing might be very much unconstitutional. I am waiting for the actual order of the court, which will then clear the air as to what he really ruled as against this very lengthy judgment he gave. So it is important then that we understand that by virtue of an attempt to politicize the judiciary, we heard of these professors saying that they're trying to judicialize our politics, but politicizing the judiciary by virtue of trying to control them by virtue of not giving them the autonomy. You see, when you don't give this judiciary the autonomy in its relation to its budget, you can then go and tell them anything after that, because whenever they want to go to a conference, say in Delhi or in Johannesburg or wheresoever there is a big judicial conference, you have to literally go with a begging bowl to say that I need to get a trip to the country and hotel expenses and all that. But when you tell them that, look, they have $3 billion, they will know how to deal with that kind of thing. And the National Assembly, as its larger body, passes it, not Ashni Singh, who will come under direct control by Jagdeo and Irfan Ali. And that is politicizing it. The other aspect is, of course, as was mentioned, is where they're using the courts to drive fear. Paul Slow didn't do anything. Justice Ann Barlow, in a recent case, said a man was there for 5 years and there was no evidence for him to charge him for murder. You know, and the police force is being used now in a number of cases, whereby, like Chris Jones' case, there's so many other cases. What you have, by virtue of bringing these people to court, hardly will ever there be a conviction, is to drive fear into those who might want to come out there and protest, those who might want to come out here and argue against the government and show their resentment to it by, well, I ain't going nowhere. I'm frightened and I'm fearful, and as a result of that, the PPP will have its way. But they don't know the explosiveness of the situation that they're creating by weaponizing and doing all of these mad things, abuse of the process, misuse of the process.
Roysdale, let me get you back in here, because you did mention the Office of the Director of Public Prosecution, the DPP, which is an important office in the legal system. Explain for our audience the functions of the DPP, and then talk about how the DPP, the office of the DPP, is being used as part of the weaponizing that you talk about.
Well, under the Constitution, the office of the DPP is a very important office. It is not necessarily considered by the ordinary citizens as a very important office, but within the constitutional scheme, it is a very important office. The DPP essentially is in charge and has the power to institute criminal proceedings, to bring criminal proceedings to an end, whether they're instituted by the police or any private individual. That, in summary, I believe, captures the functions and the constitutional power that the holder of that office would have. But by virtue of just simply stating it, it requires that that person exercise a certain level of independence and bring to bear a certain level of consciousness as to what is happening in the society, and ensure that the system operates fairly. So what we happened that Kemraj simply referred to there, where a man was on death row essentially for 5 years on a charge for murder, should not have happened. And it is my belief that the office of the DPP is not being used sufficiently as a filter to prevent those charges which are simply abuses and simply that don't have any substance to them. So the reason why I included the DPP, and I think it's important to have that office included in this discussion, is to recognize that long before we even get to the line of the court or to the gates of the court, that the office of the DPP stands there first as a guardian and a protector of the rights of the citizen, that makes sure that you should not be subject to wanton prosecution. So I hope that I would have captured your question and answered your question.
Roysdale, and let me put this question to both of you. Roysdale first, and then you, Kemraj. The courts have come under the microscope a lot, especially since last year. different levels of the courts seem to have ruled differently. And the supporters of one side or the other seem to disagree with the court. Do you all as legal practitioners, do you all have confidence in our legal system in order to dispense, do you have confidence in the legal system, in its ability to dispense justice in Guyana? Let's start with you, Roysdale.
Well, Dr. Hines, I have confidence in the legal system to dispense justice. There will be decisions that will be pronounced by judges within the legal system, which I believe will not necessarily accord with my understanding of the law. And that would happen from time to time, and it would necessarily correlate with my appreciation of the issues and how they should be resolved. So you have to draw that distinction between your personal view as a citizen or as a politician, and then you have to draw another distinction between your appreciation and analysis as to where the judges went wrong or right in terms of their decisions. But as a system, as a whole, I have fundamental problems with what would have been said by the professors.
Yes, and I'll get to that. Kemraj, your confidence or lack of confidence in our legal system?
I have tremendous confidence in our legal system, especially our judiciary. And that is why I want to believe that the judiciary too must also ensure that that confidence rests on very firm foundations. And that foundation, one primary pillar, is the Constitution. And if the Constitution says you must have financial autonomy, then the courts must so rule. And I think that Justice Harnanan did as best as he could a ruling that is supportive of that. People will want to misrepresent what he ruled, but of course, as I said, we can all then go back to, let's say, a court of appeal, and then right up to a CCJ for clarification of the issues. Remember, right up to the very first case in relation to the no confidence motion, we had legal debates as to what it is numerically. And of course, we carried it right up to the apex court, the CCJ. Some people didn't like what the CCJ said, but you have to respect the institution. It is like the umpire raising his finger. You walk. And the convention is that we respect that separate entity. When the court ruled in certain other ways favorable to us, we must appreciate it. And those who are not liking the court's decision must understand that it is an institution that must be respected. And unless it gets so egregious, like courts in certain other autocracies and authoritarian dictatorships and in non-democracies, if I may call it, or even illiberal democracies, well, we could understand that. But I was, as president of the bar, very supportive of the CCJ, and I was very happy to be there in its inauguration. I think I got one of the hammers here. This was a little memento they left with me, and those lawyers that went over there. But the CCJ could be regarded, being the apex, as the body that could even if we want to think that our High Court or our Chief Justice and our Court of Appeal might have certain nuances to their decision that plays to the politics of the day, there it is where you're supposed to have a dispassionate set of very elderly and senior judges who can quell all of that sentiment that can, get us feeling riled up. And that is why I believe that indeed. And that is why it is a court also that helps to reason out its decision very thoroughly. And so I believe that in knowing very well that no judge or no court is infallible, they might be supreme. They're never going to be infallible. But, you know, the argument can be made that they allow it, that you can criticize their decision. Remember, in our democracy and in our separation of powers doctrine, the judiciary is always right, because there is no other place that we can go. If we want to go any other places on the streets, and that could get very bloody, we do not want to go there. So when the CCJ makes a decision, we have to regard it and move on. Try to get probably different arrangements legislatively to change probably that, but then you do it at an executive branch level or a parliamentary branch level and so on. But you simply don't go hounding down a court system or attacking an appeal court or attacking the high court or whatever. It is our surest bastion, in my view, of democratic rule and rule of law. And we must really regard it.
We seem to have lost Kemraj there. Raj, let me read this for you by the law professor, the law lecturer, Ronnie Yearwood. Here is a quote that is reported in the Stabrook News. It seems often that the High Court and the Caribbean Court of Justice were on similar wavelengths and similar thoughts and reasoning. It was often the Court of Appeal where the judgment seemed to go awry. And then the CCJ correcting the Court of Appeal to say actually that the High Court originally ruled as the exclusive court to deal with electoral matters was right. So we often saw that happen. Comment on that, please, from you, Roysdale.
Dr. Hanks, I find it quite astonishing to go through that sort of analysis. The court system, having the three courts, the High Court, the Court of Appeal, and the CCJ, excluding the issue of electoral matters and political matters, which these three professors sought to engage as the basis of their research and presentation. It is a common feature throughout the Guyanese court system, the Caribbean court system, in which matters go to the Privy Council, in the United States, throughout the Commonwealth, that what happened there happened throughout the world. And I don't believe that there's anything peculiar about the fact that simply that the High Court ruled one way, the Court of Appeal ruled another, and the CCJ ruled in another way. There's nothing peculiar about that that indicates a lack of independence. For example, Dr. Hines, one of the matters which were actually referred to as the basis for this opinion that the three professors arrived at, it was the case dealing with the appointment of Justice Patterson as the chairman of the Elections Commission. But what they did not say clearly is that that case stood contrary to the proposition they had advanced. In that case, the High Court ruled that Justice Patterson's appointment was proper. The Court of Appeal ruled that Justice Patterson's appointment was proper. But the CCJ said that both courts were wrong. So how can you use the fact that simply courts rule in alternative ways or in different ways on one matter to indicate that the courts are somehow lacking in independence? So I'm quite astonished by the ruling. And you know, Dr. Hanks, you would know more of this than me because I'm not a social scientist per se, but I'm concerned about the sample that would have been utilized to arrive at such a profound position. This was a period of 4 or 5 months, well, going back to Justice Patterson's case, of about a year or two, in which you had about 5 or 6 cases, at most, if so many. And you make such a profound conclusion. And there are other issues, if I could go on, continue, Dr. Hanks.
Yes, go right ahead.
There are other issues which underpin the analysis. This is the Constitution of Guyana. And as Kemraj pointed out earlier, the courts have to play a fundamental role in resolving disputes. So where are we to take the disputes between the political parties? All the disputes are underpinned by a different interpretation, a different understanding of a legal issue. But it is not a political question per se. It is all to be resolved by the court's analysis, interpretation, and answer to those questions. And I believe rather than seeking to make Guyana the bad child of the Caribbean again, what the period offered the professors were something that they never took control of, and they never included in part of their analysis, that we actually provided the rest of the Caribbean with a blueprint as to how to resolve these matters and to maintain stability in the society. And the reason why that happened, because the courts provided a mechanism for the resolution of the disputes. And not that the parties accepted that the courts were right, but they accepted the decision of the court as being final. And I believe that that is something that should have been lauded, and that probably should have been the basis of the presentation that the three professors made. Because, Dr. Hines, I made a little note of what was said by the lead professor. I don't want to impute anything to anybody.
Yes.
I don't want to impute anything to anybody. But then you proceed to say that the decisions are questionable only because it stands different to the High Court decision, and it stands different to the Court of Appeals decision. We have not seen in their presentation any analysis of the decisions to say that they are questionable. Yeah. I believe that the CCJ's decision is questionable. Everybody could agree and say whatever they think is questionable. But what I found very strange, Dr. Hines, is that there was no analysis of the decisions to justify this profound statement. Without saying that you don't want to impute anything to anybody, you certainly would have imputed things to the judges that sat in the Court of Appeal, things that certainly are not honorable.
Yeah. Kamat, let me get you in here.
Yeah.
Your initial response to
very supportive of the response given by my senior counsel here. Look, the court system is accessible on almost every issue. There is nothing that prevents a court of law from determining questions that any citizen who is not a busybody to bring in there. And all those questions that started off with the Colada matter and so many other matters, they were all genuine matters which a court has a final say and which will be respected by the parties and even the broader society. And that is one of the big pillars of our democracy. The other has to do with GCOM itself. Our constitution makes provision that the chairman of GCOM must be a person with judicial status, and also must have a bearing about him or her, which has to do with the law. What that says is that our constitution, our main document, the Bible of our democracy or the Quran or whatever you want to call it, but the source document is saying that everybody literally got access to the courts. And now in GCOM matters, the chairperson, knowing that you got three politicos on one side and three politicos on the other side, must be a person who is qualified to be a judge and all of that. Why did it say that? It says that because electoral matters, apparently, the constitution framers thought, would have come in to be a lot of legalisms, a tabulated set of legalisms. And so that is why I believe that it was very undiplomatic for the two professors to say as they did when they tried to insinuate that the Court of Appeal might not be independent simply because the Court of Appeal was reversed by the CCJ. Mm-hmm. It is a terrible mistake they made. And I don't want to do what is called a severe criticism of them. That severe criticism would come from other professors. But I would simply say that it was largely undiplomatic. As to the timeliness of the thing, I have some suspicions.
There you go.
These professors know that there is a big call by all the political parties in Guyana that we should appoint the present chancellor acting as chancellor and the present chief justice acting as chief justice, and make them substantive holders of those offices. And this, at the back of my mind, I am wondering now when they try to insinuate an attack on our appeal court, as if they want some other set of people to be appointed as the chancellor and the chief justice. And that is a thing that could be used, because having heard some of the PPPites on this matter of the attack on our Court of Appeal, you get the impression that some of them now want to give them that there is good grounds not to make the chancellor the chancellor.
Yes, yeah.
You know?
Yeah.
And they had indicated a long time that they would like to see the appointment of these two persons. Now they are in government and they have not done it. Well, what's going on? And then next thing you get is somebody attacking our appeal court. It is a very sorry state of affairs, because I happen to know the PPP. They are control freaks. This is an aspect of it. But you could get that these two professors now come, and the Honorable Attorney General will say, well, you hear what the two professors said, boss? And then we don't appoint them, because they don't want to appoint them. That is, again, something that is to control the court system, politicizing them, to say, well, you stay just where you are, act, and so on. And you know, it's something at a level. It's something at a level that I was very much against. I had pleaded with the former president too that he must make the appointments. Of course, at that point in time, there were some differences and so on. But now that the PPP had indicated that yes, these are the two most foremost authorities in our land, why not appoint them?
Why not?
The AFC, I have already said that they're two very brilliant women. Get them done. Sometimes they give decisions that we might not all like, but that is not how the thing goes. There are umpires out there. Sometimes the decision is not well liked. You got to walk, because the conventions of our democracy too is that you must respect them. And that is what I believe might be this is a suspicion on my part, to utilize the professor's attack in not wanting to do certain appointments.
Yes, and Comrade, look, and I'm pausing this because I have no problem with academics saying, look, I am critiquing the legal system, the judiciary in Guyana. But what they're doing is cherry picking. They're picking one level of the court.
Yes.
And that is what, and I would like both of you to comment on that. For me, that's where the suspicion starts. I have no problem with academics, like I said, critiquing the judiciary and so on. But you are picking one level of the court. Why? Why? It says to me that you seem to be saying that the courts in Guyana are taking political side, but the one that takes the political side of a certain side is not independent. But the other one that rules in favor of another side, you get a vote of confidence. Please comment on that, Hemraj, and then Royce-Dale.
No, well, that you are right about that critique. Look, there is something in our Constitution again that says there is a freedom of expression.
Yes.
And the freedom of expression means that professors can critique and probably can write what they want to. But at that level, you have to be extraordinarily analytical. And the basis here, as even mentioned by Senior just now, is that they didn't do any analysis. They didn't. They kind of missed a couple of cases in which the Court of Appeal even supported the High Court.
Yes.
You know, and then the CCJ ruled against both. But they cherry-picked, as you say, our appeal court. So this is a tremendously dastardly comment, if I may say so, was not well reasoned, and it was undiplomatic about our Court of Appeal. And I rather suspect that it is going to be used, as I said, and that is the danger here. The public's interest will not be served by these, comments, and they can be used by the present administration not to make the appointments. And I hope that that is not going to be the case. But I have a suspicion. And the fact that these two professors did what they did at this time, and knowing that one of the professor was the person in charge of that CARICOM team and all of that, they made their report. Why you got to now go and do a kind of a professorial attack on our appeal court? Who got them to arrange, or who arranged that? The thing, you got to dig a little deeper, in my opinion. And knowing how the control freakism will get a little more sophisticated from the PPP, did they arrange that those two people come in and make their statements and all of that, and make that kind of statement? Look, this PPP, you got to understand, get advice from some of the top people from Analytica, Cambridge, and Mercury, and all of them people. So they know how to do this thing and propagandize, and they got their own people too who are teaching them and telling them what to do, how to create this division now, and divide and rule even within the judiciary. And all of that. And so this is what you're going to get. And they want that judiciary to be under their control. So I believe that there is a piece of mischief behind it.
Rosel?
Dr. Hanks, I would take the position of Kemraj because I agree with him. I believe that what is really happening here is that it's effectively a hatchet job. I don't know the source of it. I have my suspicions that the government is behind it, and the Attorney General may have some role to play in this. I do not know as a fact. But I find it strange that such a report will come out. Dr. Hanks, one of the issues that I wanted to bring to the attention is just more than what Kemraj pointed out. And again, in assessing the independence of the judiciary, even in the context of the judicialization of politics, the professors failed to recognize that what the courts were doing was a fundamental court function, which is to decide controversies. So to describe it as judicialization of politics is very concerning. But one of the things that I wanted to bring to your attention and to bring to your attention and the listeners is this. Today, the Court of Appeal heard another hearing, or had another hearing in the election petition appeal. And I found it extremely interesting that just a few days before the court sat to hear another important case, another case fitting the description of the professors as a judicial matter concerning or relating to politics, that this highly questionable itself report, lacking in analysis, in my respectful view, would have dropped out of nowhere. It took my mind back to what happened during the period when every time the court is supposed to sit to make a decision, very conveniently, we would have had some statement, some report, some ambassador, some secretary of state issuing or making a statement just before, maybe sometimes hours before, the court sat to make a decision. I believe that would have been much more fertile ground for the professors to analyze the response of the courts in the face of those statements and positions. Because without being a social scientist, I could come to the same conclusion, that the court's decisions reflected external responses made by diplomats and ambassadors and so on. It could have all be coincidental, that the judges had decided that they were going to rule this way anyway, notwithstanding that 2 hours before Pompeo said X, Y, or Z. So I believe that provided another interesting dimension as to the reason and the potential circumstances which would have led to the presentation of this report?
Yeah, I am part of the academic fraternity in the Caribbean. I present at conferences, and I can tell you, our scholars in the region have a difficult time understanding Guyanese politics. They often begin their assessment of our politics as if they're assessing politics in St. Lucia or Barbados or Jamaica. And I've encountered that for decades with our fraternity. And they don't take the time to understand the peculiarities of our politics. Dr. Jeffrey reminded us on this program a couple of weeks ago that Guyana is one of about 6 countries in the world that are as deeply divided as ours. And even Trinidad, which is similar to us, but in many respects, they are different to us. I mean, there are aspects of Guyanese politics that our colleagues in the Caribbean have difficulty. And so all of a sudden, you have people who have become authorities on our political situation, which for me becomes suspicious. There was no Guyanese scholar on that panel to provide the kind of understanding of the Guyanese political and legal situation that is really needed for a discussion like that. And so therefore I have to share the suspicions that that you guys have expressed there. And you take into consideration that the one members, as Kemraj mentioned, was part of observation team and presented a report that first of all took a very small sample of the boxes there. That's one. Two, made the fundamental point in the report that GCOM in its present capacity cannot provide free and fair elections in Guyana. Yet they certified that election under GCOM has been won by the PPP. You know, contradiction. So one has to be suspicious. And I said in the beginning, I want us to be very careful because I don't want us to go attacking professors. I don't want us to start saying that if you are not Guyanese, you can't comment on Guyanese politics and the Guyanese legal system. I don't want us to start attacking CARICOM and regional integration, right? And so I want to say that to our audience, right? Because they would want us to do that so that they can then dismiss our suspicions as anti-Caribbean, anti-scholarship, and so on and so forth. But I think this is a very important moment because we may believe, and Kemraj, you're right, we may believe the elections were given to one side, and the whole thing is finished. But as you, Kemraj, have pointed out, it's not finished. And as you have pointed out, Roysdale, we still have petition cases before the court. So, Kemraj, can you bring us up to date where those petitions are at the moment?
Could I ask Senior to do that?
Kemraj.
I would like Senior to do. I missed the court date today, was it? But it is in the Court of Appeal. And Senior, please help me out here.
Well, as I was saying, Dr. Hanks, today we had one of the hearings. This is in relation to the petition number 99 that was dismissed by the Chief Justice. That came up for hearing. We are deliberating in the court and presenting arguments on the issue of whether the Court of Appeal as a court would have jurisdiction to entertain an appeal in circumstances where a petition would have been dismissed without the court actually hearing the entire petition. So that is the issue right now that the court is grappling with. It came up today, and it has been adjourned to the 26th of November for further presentations. I believe by that time, myself and the other side would have to submit further submissions to the court, each one of us having 7 days to do so. And in relation to the other appeal, we would have filed that appeal, and that remains in the court to be heard. So we again, it is very disturbing that the professors choose to make these sort of statements. Very, very disturbing. It destroys the credibility, and it is an attack on the integrity of the court system as a whole. Dr. Hines, in the report that I read of the presentations of these professors, in the very last paragraph or last 2 paragraphs, there's a very interesting comment by the professors. And they said, I think it is the female professor, Cynthia Barrow, I believe it is.
Yes, Cynthia Barrow Giles.
Yeah, she said that in relation to the independence of the judiciary, they must have a complete separation of powers.
Yeah.
And I want us to discuss this.
Yes.
It is a very strange statement to make. There's no system that involves 3 distinct arms of government that would have a complete separation of powers, especially in relation to the appointment of judges.
Right.
Even in the United States of
America,
you
took it off by
the
mouth.
most profound sort of separation of powers. It is ultimately the executive who would have to find, approve, recommend the judges to the legislature, and you go through that system. So I'm wondering really and truly what is meant by this, and how are we to achieve this purely almost utopian concept. It does not exist anywhere in the world to have a complete separation of powers. And again, Dr. Hines, in speaking of the judicialization of politics, that is not the problem. That is not a problem. What is the problem is to ensure that the judges themselves are independent themselves to provide important and clear pronouncements on those type of cases. The reason why I mentioned this, Dr. Hines, is because nowhere in the analysis about the impact of the judicialization of politics was even the recognition, which is something that is clear throughout the Caribbean. For years, the presidents of the CCJ have been speaking about the fact that our Chief Justice and Chancellor must be confirmed. And you write such a profound paper, come to such profound and radical conclusions without recognizing that up to now in Guyana, Irfan Ali refuses to meet with Joseph Harmon to engage in consultations which would lead to the confirmation of these judges. And what is the explanation being offered by Irfan Ali? Is that Joseph Harmon must recognize him. And you speaking about the independence of the judiciary, you're speaking of judicialization of politics. And in that context, you could come to a number of different conclusions as to why the decisions went this way or one way, if you just want to be completely mischievous.
Yes. I think the presentation was more political than about, and I'm putting it out there that I have read. I noticed somebody in the audience there, Lamash Rupnarain, is asking that he has worked with Cynthia Barrow Giles. She's a brilliant political scientist. Have you worked with her? Yes, Lamash, I know her. We are colleagues. I know her work very, very well, and she is a political scientist. Nobody is challenging that. What we are talking about is a report and a discussion that she's part of. I think there is a political motive, and you guys have said enough for us to conclude that. I don't think this matter is closed. We have to keep. Somebody is suggesting there that what should be done by the two of you is to do a rebuttal of of or do a response to the report by the professors. I just want to draw that to your attention. Let's shift gears and go to Justice Barlow's comment. Kemraj, what do you make of it?
Well, the Barlow's comment, can hear about Justice Ann Barlow.
Yes.
Yeah.
On commenting on the guy who was on their charge and there was no evidence. Yeah.
That is an important judicial comment which we must respect, because indeed, as I am hearing from Nigel Hughes and the other lawyers who happen to have represented the client, that on the face of the record, there was absolutely no evidence for a murder charge, for which you don't get bail generally in Guyana. Now, that is taking away a person's freedom for 5 years on a basis that is totally without any justification. And that is why I believe that our prosecutorial setups, the DPP chambers, the police legal advisor, the police itself, they must ensure that they be what you call vigilant and also extremely cautious gatekeepers. The DPP is but a gatekeeper in relation to criminal matters. And you just don't willy-nilly, by virtue of, let's say, an overzealous policeman wanting to charge, you got to go carry the file to the DPP. And in our scheme of things, the DPP is that gatekeeper who, in the public's interest, must ensure that the evidence is of a sufficient quantity and sufficient quality to ensure that you're going to charge a murder. And if on the face of it, a judge is saying, and by the way, that judge was a fantastic prosecutor in her days. Mm-hmm. And she came from the DPP's chambers too. And she is making this comment that without any evidence, you keep this man 5 years there. Well, that is an injustice. That is almost false imprisonment for 5 years. I believe that that man should take legal action against the state of Guyana for that state of affairs. And so it is important. Look, justice is never perfect. And you can have even gatekeepers, even judges, the CCJ, they can make mistakes too. Of course, as I've said before, they are right because they are final. We ain't got nowhere else to go. They are right. And we must respect the finality because it has brought finality and we now know how we're going to do our affairs. So it is important then that all these institutions that were created by the Constitution, remember prior to independence, the Attorney General's office used to be the person, the office that was in charge of prosecution. And of course, the British government used to charge political leaders left, right, and center, and the public interest for criminal matters and all of that, plenty times. We set up, after independence, the Director of Public Prosecution's chambers so you can depoliticize the criminal charging of people. Of course, the PPP wants to argue, as they have argued inside of Parliament, that, we charge some of their ministers and so on. Now, I must tell you that I had questioned a couple of these things. But what we did was that indeed we had forensic audits done. And in those forensic audits in which the forensic people like the Christopher Ram and them, whosoever did it, when they say that this thing should go to the police, we sent it to the police. And then the police charged some of these fellas who are today ministers and so on. And then the DPP also went through the process and charged some of them. And so you had, quite frankly, a number of things. When they got into government, of course, the DPP dropped all the charges. Now, that might be okay. The discontinuance might be in her arrangement constitutional. But the trouble is, when you are dealing with ordinary citizens too, you must ensure that the sufficiency of evidence, if it is not there, don't charge those people. Otherwise, the whole system will come into disrepute. And it is going to be a very sad day when people start disrespecting our institutions, DPP chambers, judges, magistrates, and we can have, turmoil and the dismantling of a democracy. And, it's fledgling. It is not like 200-300 years like in America. So we must make sure that we get these things right. And so on. And I believe that is what the judge was trying to tell the DPP especially, and the police legal advisor.
Rosedale?
To your attention, I don't know if Kemraj is aware of it. Recently, the High Court Justice Holder ruled rejecting an application filed by an attorney representing the DPP in the Roxanne Myers matter. An application was filed to Justice Holder seeking to set aside a decision of a magistrate that in relation to the charges brought against Roxanne Myers, that there should be a preliminary inquiry, which means that there would be a hearing, the evidence would be brought before the court. The court will then have to make a determination as to the sufficiency of the evidence. If the magistrate finds that a prima facie case has been made out, it would then be committed to the High Court to stand trial before a jury. I find it very strange and very suspicious that the DPP will engage in court proceedings and resources to challenge a decision of the magistrate that such a matter should go to the High Court. So I'm trying to point out again to you, Dr. Hines, how the court system is being used to create certain outcomes, outcomes that the state would like to have. They would like to have a trial take place in the magistrate court without the benefit of a jury participating and sitting to hear such a case, where you're bringing charges against persons saying that they interfered with the electoral system of the country. Isn't that a case fit and proper for a jury to deliberate on? To have a trial in the presence of the peers and the citizens of the country.
Yes. Thank you. Let me get you guys in here on this matter. We had this fire at Brickdam Police Station a couple of weeks ago, right? And there was a lot of weeping and gnashing of teeth on the part of the PPP, and they made a lot of noise, and then it has gone quiet. What do you all make of it? And then I'll come back because I have something to ask you all. Starting with you, Kemraj.
Well, I am amazed that people being charged based on the confession statement of a person who is now denying that he ever said so and all of that. And you got flattened an entire compound, a whole block of buildings, literally. It smacks, in my view, of tremendous amount of suspicions, especially in relation to the guy that was charged. And all these circumstances of how he could get a match and a wire and tie it to a piece of sponge, light the match, and then put it in some crease. The thing is absurd. And I don't think that, that is probably what happened. I feel otherwise. And so it is my opinion that just to get somebody to charge and to say that the case is now closed because we have solved it, that is what they did. And that is really, really crazy. A man could come forward and say that I did the act. Policemen who are professional must go and check out the credibility of the man. They must go and check out all manner of things. And especially now that the man is saying that the thing is not true. That is not, I did that. Because you will never then solve the actual problem by getting to the truth of why that place was burnt down. And so was it for a reason of wanting to spend another $5 billion on some compound there? Another contract or whatever it is? Or, so many other suspicions emerge out of the one that is with so much reasonable cause, that suspicion that this fella burned down the place. And then next to fire service, with so many policemen there, I understand the place is supposed to have extinguishers. What went on there, I don't understand. So my tremendous, I'm
Roselle?
Yes, Dr. Higgs.
Yes.
I agree with Kembraj. I believe that it's a fanciful story, lacking in credibility. A man took a sponge, hook it onto a wire, light it, and burn down an entire police station, the largest and central police station in Georgetown. But you know, it takes us back to the quality of investigations that take place in the country, in the society at large, where persons are alleged to have given confession statements to sometimes very ridiculous propositions. But more importantly, and very sadly, we saw the quality of poor investigations in relation to the Henry brothers, the Henry boys that would have been killed.
Yes, I was going there next. Go right
Where
ahead.
you charge persons who allegedly made confessions, and the court freed them because the evidence could not support the confession. So you just simply close the matter. It's closed and done with.
Yeah. You know, the fire service, I think they said, did an investigation and came to conclusions. You guys are aware of that, of course. And then Brother Yussi Kwayana drew my attention to section 2203 of the Constitution that says it's the magistrate that is empowered under the Constitution to do an investigation, not the fire service. And it's there in the Constitution. What do you all make of that?
I have the Constitution somewhere in my desk here.
Yes.
But I can't recall a Constitution saying anything about a magistrate, is it?
Yes, 2203 here under the Fire and Casualty Inquiry Act. Yes, 2203.
You mean but that's not the Constitution.
The laws of Guyana, sorry.
The laws of Guyana. Okay.
The laws of Guyana, not the Constitution.
Yeah.
The laws of Guyana. And it says here that the magistrate
ought to do something there.
Yes.
It's like under the Coroner's Act. Anybody that dies and naturally, you have to do something. A fire of that nature ought to be. Yes, I think that there is some old law like that is somewhere there, and that is what should have been utilized. Yes. But of course, all of these things, is what will, cause so much suspicions, Doc. It is what will cause it, and people must understand that even what the law provides is now being evaded and avoided. And it's a good thing that he brought it there to our attention. So all the more, there is something rotten in the state of Guyana.
Razel?
I agree. I found it humorous that the fire department was pronouncing in one way, and the police force was saying something else. Two different things. Both couldn't gel, couldn't make sense. But what you see happening, Dr. Hines and Brother Yussi Kwayana pointed out there clearly, is that there's a progressive movement, trajectory to abandon the provisions of the law to deal with these issues. and I want to point out to you, Dr. Hines, is that it is very interesting that within hours, the entire place was demolished and removed. So what sort of investigation you would have? On Sunday morning, the Irfan Ali is saying that he's going to have international people to come in and do the investigation. And by 5:30 in the afternoon, bulldozers are cleaning and demolishing the place.
It's laughable. It's very much laughable.
Yes. Something is not right. The Boston killing, again, we had promises from the government that this process was going to be speedy. Weeks have passed, no movement. Comments from both of you, starting with you, Roysdale.
Well, Dr. Hines, I've written the police commissioner to have a meeting with him on this matter. I believe that he contacted the Minister of Home Affairs, and I have not received a response to that letter. I did receive a letter, but I don't consider it a response, saying that the dates proposed for the meeting could not have been had. This is just simply another situation where the state and the police force simply believes that they could do what they would like to do, and they have a complete disregard for human life. A few days ago, when I was in Essequibo, the leader of the opposition and myself and a number of other members of parliament visited the home of the Bostons. And, you know, Dr. Hines, I want to mention to you that we all know that he was shot and the circumstances under which he died. But it is very heartrending to see that the government remains very insensitive, very uncaring to this circumstance. We were able to meet the wife, and she was still in a state of deep shock and pain. His mother continues to be in a state of worry and apprehension over the circumstances of the death of her son and the entire family. And you see people going to Dubai and celebrating and living a good life, and simple fundamental issues that you need to investigate and resolve cannot be investigated and resolved. What the president said, Irfan Ali, the installed president, said in Berbice to the Henry families is that he would leave no stone unturned. Apparently, through other persons or through the commissioner of police, he said the same thing to the Boston family. We just had another killing at Grove.
Yes.
And it is mounting and continuing. None of these things are being resolved, and the country is meeting to the point where we cannot accept any loose talk about stones and so on. This is a very serious matter.
Yeah, Emraj, your comments on the Boston murder, but in a larger way on this upsurge of extrajudicial killing.
Well, the PPP, in my view, always wanted an unprofessional police force so that they could use aspects of it to do their bidding at any time. It came out through the troubled times. I happen to know of their attitude towards the police, and they feel that they got to set up their own arrangements if they're going to be scrutinized, that they can't get the regional policing security organizations done. They will have to extract that part of the police force that they feel is supportive and would be willing to do all the machinations that they will direct. That is okay with them. Now, when you do that, the literature and experience teaches us that there is going to be a runaway faction of that police force that are going to do all this madness. And it will become then very disreputable. And some of them can do these extrajudicial killings on behalf of certain businessmen. It has happened in other countries. It has even happened in New York, in America, whereby the police force has certain rogue elements inside very close to the politicos, who will then do their jobs. We know from the George Bacchus time that is what had happened in relation to this PPP government then. I remember the fellas coming and talking to me and Moses Nagamutu, and I telling Moses, you better go and tell the PPP Freedom House what they're doing, and this is what is happening, and so on. He went and he told them. And we had how many people dying? Too many people dying.
Too many people.
I believe that is what has happened. And it is very striking, in my opinion, that there has been a complete dismantling of the reforms of the British security sector reforms. We spent a set of monies in ensuring that this police service, the police force work for service and protection. And almost everything from the Russell Coombs report, almost everything in the other recommendations made by other people who were experts from England and so on, coming to say how you do the arrangements in relation to crime scene development, how you approach people like the Oren Bostons in doing your work and all of that. And also other things, budgetary allocations within the police force, so that you don't have corruption of big sums of money being stolen by senior officers and so on. All of that, about 11 reports. And it is the point of implementation, because the money was used to get all these reports. And the recommendations now were supposed to be done by the next administration. And we said that we, of course, going to do all of that with, of course, the oil monies, via the committee that is in Parliament, that would ensure that these are very positive things. They will support it, and then we, the parliamentarians, will approve of it and then vote for it. But all of that has now come to naught. Even the oil monies, they don't want to utilize. They're saying they want to go the Kazakhstan model. So there has been a total dismantling of the security forces as we and the British had engaged us with, and had, in a sense, redirected away, knowing the history, away from that troubled period. So public security was now supposed to be something very much community-oriented. Policemen must be seen as big brothers rather than bullies, and things like that. And all the rogue elements must get out of the place. You must set up your institutions to get them out of the place. But they are now being stacked up against the more professional ones. And we're going to have what we are having. You get this SWAT team going up there and one member just shooting her in Boston. And then that not being the only time they went there, So on the only place they went on that Essequibo coast, they went to a client of mine. They went afterwards or somewhere else and so on. This is what they're doing. And you don't need a SWAT team to go to Essequibo to arrest a businessman that is very popular, dancing at all them East Indian wedding house and so on. You could have gotten your Anna Regina detectives going and take the man down, but they want to drive fear. Because just a week prior to that, Irfan Ali was there in Essequibo, and people were talking and pointing out who talking what and what and what. And he said, all right, I will look into it. Well, when you're going to look into it, you don't send your SWAT team. You send the detectives, or a better set of detectives from Georgetown, to go and check out what it is that these complaints are about. You're going to send a SWAT team on an innocent man, shoot him and then lie and say he was trying to attack them, shoot him in his bed, the mattress get blood, the wife is testifying to that. Oh, gosh, man. And, we are not getting the right, the investigations, it would seem, going. Nothing. And even that policeman that fired that shot, I don't know if he has been charged. What is going on right now?
Right now. Rosedale, we're coming down to program time. Are we, should we be concerned about this, what seems to be this coordinated attack on Paul Slow?
Of course, we should. Dr. Hanks, that is simply another example, just more evidence of the politicization of the courts. Kemraj mentioned that earlier in relation to Paul Slow, the fact that he would have done nothing wrong, the fact that the government acted in a manner to first remove him and then institute these charges, which I have every reason to believe they were without any substance. You saw the almost insistence and determination by 4 police officers grabbing him by his pants and his shirt and holding on to him to take him to the police station where the man came to court to answer the very charge that you want to take him away for. It's just complete nonsense.
Yes, yes. And Rosedale Fort, Kemraj Ramjatan, quite a discussion tonight. There are lots of responses from the audience. As usual, they're on the ball, but obviously our program tonight really has shed a lot of light on these matters that we've dealt with. Any burning issue that you all want to mention before we close? Starting Kemraj.
Well, look, there is another burning issue in the Public Accounts Committee that I want to bring to the attention of people. And that has to do with what they're trying to do by virtue of saying that you can't bring up the backlog. Remember, they're dealing with 2016 public accounts. Yes. Scrutiny of how our monies are spent present day is important. And if you want to keep the country's backlog all in one place and carry on and time being spent there and the time being stalled, that is one way of you're going to get away with the scrutiny of what you're doing today. And today we have COVID relief corruption, flood relief corruption, corruption in all quarters. And they don't want the PAC to stalk and scrutinize that. That is another dismantling by the PPP of an institution of democracy, our financial architecture being scrutinized by that parliamentary body called the Public Accounts Committee. So it is a variety of places all across. And this is a very important one that people should start taking a look into to find out yet again what the PPP wants to do. And that is to ensure that there is no scrutiny of their administration right now. What is it? We in the coalition government, I think, are 2 or 3 weeks, the entire days of the week, excepting Saturday and Sunday, the PAC worked. And the PPP wanted that to bring it to the present day at that time. That is the 2015 or some such thing. Now you're getting it stalled up. It is not right. And then Gail Teixeira, with a straight face, literally lying to the members of the public. Jermaine Figueroa had to correct the situation. And they're utilizing all of these pieces of mischief. I still believe that it was wrong to knock off David Patterson as the chairperson the way they did. But of course, the committees have, now Jermaine is there. But please allow another day to come so that you could do away with 2016, 2017. You could come to 2020 and let me start seeing how they're spending the money. Yeah. It's a lot of thievery. Yeah. I would like to close on that. Yeah.
Yeah. Anything you want to? Yeah. Go ahead, Rosedale.
On the same issue that Kemraj raised, and I would like to deal with one aspect of it. I find it very worrying that the clerk of the National Assembly will send out a letter to the public, because it's the public he will be writing. He will be writing the committee, but he's basically writing the public, to tell the public that the Public Accounts Committee really cannot meet after the committee would have decided and rejected the statements of the Gail Teixeira and her gang. He will then, at the last minute, to try to prevent the committee from meeting, to obstruct the operation of the Public Accounts Committee, he would send out a letter simply saying that the clerk of the Public Accounts Committee is unwell because of suffering from the pressure of hard work, and there's no other clerk at the Parliament who could sit to hear this matter. I find it disturbing. You know, the person who wrote that letter is the chief clerk of the National Assembly. He is the chief clerk of the National Assembly. And if none of the clerks below him, subordinate to him, could sit, it was his responsibility to attend the Public Accounts Committee and sit. Because in other matters, the clerk wrote us saying that he is ultimately the chief clerk, and he would have to decide who could sit or who can't sit in terms of clerks of the National Assembly. And then we have the other issue relating to this, where the members of the Public Accounts Committee, the government members, are providing explanations and having improper discussions with the Auditor General and the Accountant General to explain their absence or presence as required to come before the Public Accounts Committee. So these are very worrying developments, but they're not developments that we should be extraordinarily surprised by, having regard to the governance and the nature of the governance of the PPP. And I believe these matters themselves constitute fertile and good ground for the sort of academic discussion that Cynthia Barrow and her colleagues should want to get their hands into, as to how you could accept being elected, whatever manner you've been elected, but progressively run the country contrary to the Westminster system and contrary to our constitution. And that is the sort of debate and the sort of academic value that I believe their efforts would have been more targeted towards.
And on that note, I want to say thank you, Roysdale, Senior Counsel, Shadow Attorney General, and Legal Affairs person on the opposition side, and Kemrat Ramchatan, leader of the AFC himself, and attorney. I want to thank you all for coming on tonight, and as usual, helping us to continue this struggle, to keep our people mobilized, to keep our people informed, and to keep up the pressure on the government of the day. Thank you all so much. And to you, my audience, I want to say thank you. I am always so proud. I don't get enough time to acknowledge everybody, but I want to say that without you, there is no program. My brother Compton Older, good night, Nigel Hope. I'm seeing some Pamela. I want to say thanks to you all for staying. On Thursday, we're going to have an analysis of the race for the PNC leadership. We're going to have two journalists, Adam Harris, who should be known to everyone, and the editor of Demerara Waves, Dennis Chabral. So we're going to have two journalists, and we're going to have Professor Henry Jeffrey. So big show on Thursday. The lineup, Dennis Chabral, Demerara Waves, Adam Harris, veteran journalist, formerly of Kaitour News, and still at Prime News. And Dr. Henry Jeffrey, political scientist and one of our in-house analysts. Until Thursday, be good to yourself. And those of you who are leaving to go to In the Ring, say hello to Sherrod for me. Sherrod is really giving them hell. Good night, Sherrod. Over to you. Bye now.
Please help keep Politics 101 on social media and broadcast television. If you are in North America, please donate via Cash App or PayPal.
If you are in Guyana and the Caribbean and don't have access to Cash App and PayPal, email your pledge to dhines6106@aol.com and we will direct you how to get your donation to us. Thank you in advance for your donation.